We have 8 documents, court filings to go over before Lori Vallow has her trial begin officially. Jury selection begins on Monday, the 31st of March, with the trial itself set to begin the following Monday. Update: since I recorded this, we have a jury. We finished out April Fool's Day with a full jury of 12 jurors and 4 alternates. We're getting close because Charles deserves justice just as much as JJ and Tylee and Tammy Daybell did. If you're unfamiliar with this case, this is the Lori Vallow Daybell. I hate adding that to her name because she wants it and I don't like giving it to her, and Tammy had that name. She is convicted of the homicide of her 2 younger children, Tylee and JJ, and also of conspiracy to commit homicide of Tammy Daybell. And then she married Chad, Tammy's husband, a couple weeks after her death.
What?
They'll never see the light of day as free people. Chad got the big old DP, and she got 3 consecutive life sentences. She has been extradited from Idaho, where she got those convictions, to Arizona, where she is about to stand trial for the murder of her 4th husband, Charles Vallow. And then after that trial, she will stand trial again for the attempted homicide of her then nephew-in-law, Brandon Boudreaux, who was married to her niece, Melanie. Melanie is one of the family members who drank the cult Kool-Aid and went to Idaho with Lori and Chad and all the doomsday craziness. So that's what we're covering today. 8 of the last-minute filings in the Lori Vallow case before we go to trial. If you're new here, I am Annette Lyon, USA Today best-selling author of the suspense novel Just One More and a whole bunch of other stuff. Also award-winning author, former editor, a whole bunch of other things. Here we discuss true crime often, but not always, where it intersects with religion. And then we have chocolate on the side because you gotta have something sweet in the middle of all the bitter. I have opinions. I rant. That's what we do here. We respect all faith traditions and those with no faith traditions. That includes my faith as well. A quick reminder to like and subscribe. It really helps the channel and helps other people find this kind of content who would be interested in it. Ready? Let's go. So Lori, she is now acting as her own lawyer, meaning she is pro se. And so that slows things down a bit. Lawyers can be a little more efficient. But I have heard people like Peter Tragos, if you watch The Lawyer, you know, he has said she's doing better than most pro se defendants. That's not saying much, but she is doing better than most. Okay, the first one I wanted to bring up was an important one that harkens back to the Idaho trial. In the original case, before Chad and Lori's cases were severed, the defense put Nate Eaton on the witness list. If you're unfamiliar with Nate Eaton, if you followed this case at all, you've at least seen his face and heard his voice, if not known who he is. He is a journalist with East Idaho News. He's been following it since day one. He's the one, if you've probably seen, if you've seen the footage of Chad and Lori in Hawaii, and a journalist kind of trying to get them to answer questions as they walk along, that's Nate. He's been there for the whole time covering this case. So when the defense of Chad and Lori put him on the witness list, he was like, hold up, no. I am media, I am a journalist, I am reporting on this case. I need to be able to report on it. In cases like this, you get the exclusionary rule, which means if you're on the witness list and could be called to testify, then you cannot be in the room watching the trial, or even if it's being streamed somewhere, you cannot watch the trial at all. So Nate would not be able to report on it, and this has been his story for forever, even if they never called him. But if he's on the list, he could be, so he can't be exposed to the trial. So he managed to fight it. Some other journalist groups helped him fight it as well, and eventually the defense lawyer team took him off the witness list. But this was Lori pays attention. She might be delusional and a sociopath or a narcissist, but she's not stupid. In March of 2025, she added Nate Eaton to the list of witnesses she wanted to call in her case in chief. No surprise to me, Nate was going to fight it. Of course he would. So since she is going to be on trial for 2 different cases, again for Charles Vallow and then the attempted murder of Brandon Boudreaux, Nate had to file for both. And he made a real point of saying, he's like, look, my only involvement in this entire case has been as a reporter. It is my understanding that by simply listing me as a potential witness, I can be barred from the courtroom during Ms. Daybell's trials. This seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext to simply keep me out of the courtroom and interfere with my ability to report. Such an effort clearly interferes with my First Amendment rights. As a reporter, and the rights of his employer, meaning East Idaho News, to view and report on the events of the trial in the same manner as any other member of the media. Thus, listing me as a witness results in harm far outweighing any claimed usefulness. There is no legitimate usefulness in listing me as a witness. Further, that risk of harm cannot be eliminated by a less substantial restriction of discovery rights, as it is not the disclosure of my identity that is harmful, but the abuse of the rules of criminal procedure to list me as a witness in order to interfere with my constitutionally protected rights and duties. Therefore, I request that the court strike her attempt to list him as a potential witness. That was on March 26th of 2025 that he submitted that. He literally has no firsthand information of this case. Everything he has is based on secondhand documents, on witnesses telling him stories. It's all literally hearsay. No matter how meticulously he has researched, it's still, from a legal standpoint in a courtroom, it's still hearsay. So the only reason is to keep him out of the courtroom. Not cool. That was an emergency filing. He filed it pro se, meaning, again, without representation. Lori had requested that she could wear civilian clothing all the time when she's having her hearings. And the judge said, no, well, I'll let you wear civilian clothing for the trial, but all the pre-trial management hearing stuff, you will be in your court-issued jumpsuit, jail uniform, whatever you want to call it. So that order was reiterated on the 26th of March. All of these are in the last little bit of March. There was just so much coming through the pike. Most of it was all on one day. So the judge reiterated that, and then the sheriff's department came out with their statement about how they would then be dealing with the security. Normally, inmates attending trials wear a leg brace and also an RACC belt. Don't know what that stands for. Someone can enlighten me. Essentially, is this belt that you put under your clothing that is not visible from the outside. You can't tell you're wearing it, but if you are trying to, like, say, flee or something, then the court officials who have the controls can zap you and make you incapacitated so you cannot run. The leg brace also limits mobility, and then oftentimes you'll end up with handcuffs, leg chains, and the inmate uniforms, but those are not usually in the courtroom for trial, and that's specifically to prevent, as the sheriff says, the jury from knowing the defendant is currently an inmate or for prejudicing the jury. So they usually will take off the visible restraints, but often leave the leg brace and the belt on. And they're saying, however, since she is representing herself, that the leg brace isn't going to work, probably because she needs to be able to move around a bit more than other defendants, because moving to the podium and back again and all of that. So she will not have the leg brace, but she will have the belt. They think that based on her past behavior in court, she's not too much of a risk. She's always behaved. And they're saying, well, we'll keep the belt on and we'll let the leg brace be off. That can change on a dime, of course, depending on how the case progresses. So the management conference for the trial first is listing the charges, that if she is found guilty, life without the possibility of release on any basis until a minimum of 25 years. She could get 25 to life for conspiracy to commit first-degree murder of Charles back in July of 2019. Tylee died early September, JJ mid-September, and then Tammy died in October. Then they got married in November. The settlement status is that there is no plea offer on the table, no settlement conference has occurred, and they are not going to discuss any more settling of any kind. We'll have 12 jurors and 4 alternates, which is a little bit lower than we had in Idaho. I think we had 12 jurors and I believe 6 alternates, something like that. The state's witnesses are mostly government officials. So We have 10 names listed from the Chandler Police Department, 3 retired, I assume, since 2019 when this all went down. We have 2 from the Chandler Fire Department. We have Jeff Moberg from the Department of Public Safety. Then we have Dr. Derek Baumgartner, who says OME, I believe that's Office of the Medical Examiner. Then we have Office of the Inspector General, and this is, I believe, on the national federal level, because it's Mark Sorry, Finnish last name, just a little side note, testified in Chad's trial, and I believe in Lori's as well. There will also be a representative from Banner Life Insurance, because, as we know, that's one of the motives that the state is alleging of life insurance money. So then the state has 5 civilians listed, people who are not like experts in whatever fields. We have Christina Atwood, Adam Cox. Adam Cox is Lori's brother. She had 2 brothers. There was Alex, who passed away in December 2019 from supposedly natural causes. A lot of us think that something may have expedited his passing. He was the trigger man in Charles's case, and likely was the one who did a lot of the offing of the other people as well. Trying to use terms that are platform friendly. Adam is her other brother. Then we have Nancy Jo Hancock, Serena Sharp, and Kay Woodcock. There are so many players I am not recalling off the top of my head who Christina Atwood and Nancy Jo Hancock are. I want to say Christina Atwood is part of like the 7 women who would gather and do those little prayer thingies. I'll look it up. So if and when they testify, well, no, and remember, Kay Woodcock. She is very significant to this case. In a lot of ways, you could argue this whole case got rolling thanks to her. She is the biological grandmother to JJ. She and her husband, Larry, initially tried to take care of baby JJ, then named Canaan, because his parents were unable to due to legal and drug stuff. And they said, we're not really equipped to handle a high-needs baby like this, because he was born addicted to drugs. He ended up having somewhat, I don't know how severe, but he has autism that made him, anyway, he was a high-needs child. So Kay and Larry felt that maybe somebody else would be better equipped to fully raise him, but they wanted to be very involved in his life as grandparents. So Kay calls her brother Charles Vallow, the victim in this case. She called Charles, and then he and Lori then adopted JJ. But when all of this weirdness starts going down in early 2019, Charles is like, what if something happens to me? What's going to happen to JJ? So he changes his life insurance beneficiary from Lori, who is talking like a psycho and threatening his life, to his sister Kay, so that if something happens to him, JJ will be taken care of. Lori finds out, and it sounds like he briefly switched it back to Lori, and then, without her knowing, switched it back to Kay. Lori had no idea about this, and then she got really pissed later. We'll get to that. In November of 2019, the same year, Kay has not been able to have her regular phone calls with her grandson. Lori will not let JJ come to the phone. And finally, she's thinking, this is not cool. Something is going on. Something is very wrong. In fact, Lori has up and moved, hasn't told anyone where they're going. Kay figures out, does her little detective work, figures out they're in Idaho, and she calls to make a welfare check. That's when the police first realize JJ's missing, and oh my goodness, his sister Tylee is also missing, and that's when the ball really started to get rolling. They estimate that the trial will take 5 weeks. Here is the brief statement of the case that will be read to the jury. This is essentially the nutshell of what they're going to be arguing. The state alleges that on July 11th, 2019, at approximately 7:37 a.m., Charles Vallow arrived at 5531 South 4 Peaks Place, Chandler, Arizona, to pick up his son from the residence where his wife, Lori Vallow, and then in parentheses, Lori Daybell, was living. The state further alleges that Lori Vallow Daybell conspired with her brother Alex Cox to kill her husband, Charles Vallow, so she could marry Chad Daybell and obtain money from Charles Vallow's life insurance policy from Social Security. Special jury voir dire questions will be filed separately, and then the list of standard jury instructions will also be filed separately.
5.
It intends to admit evidence that the murder was committed for financial gain and to allow the defendant to marry another person, meaning Chad. Doesn't say that, but we know. The state will admit this evidence to prove the murder was premeditated and to show the motive for the murder was to obtain the proceeds from a life insurance policy for Charles Vallow Social Security payments for her surviving child, which would be Colby, and herself as a mother, and to allow her to marry the person with whom she was having an affair. Evidence of the premeditation and motive will be shown through witnesses and iCloud documents, much of which I imagine we've already seen in the other trials. The state will call a witness from Banner Life Insurance Company to show that the defendant contacted the victim's insurance company within 4 days of the murder of her husband to collect the proceeds because she believed she was the sole beneficiary. Right. During this recorded call by the defendant, she provided a different story about how her husband died by telling the life insurance representative that her husband's death was an accident. And I believe we have a recording of her also saying it was a heart attack. So at least 3 things, potentially, but okay. When the defendant learned she was not the beneficiary, she advised the person she was having an affair with, again, Chad, quote, "So I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. They can't tell me who, of course, but it's done. I'll still get the $4,000 a month from SS." So as we know, the whole, we think it was probably Ned. That is the name for the supposed demon who had taken over Charles's body. Charles was no longer in his body, and it was this demon named Ned. Okay, so it was probably Ned who did it. Sure, Lori. But it's also a little disturbing that she knew how much she would be getting from Social Security after his death before she even contacted them. And that's partially because earlier that year, her third husband died. And it was ruled natural causes, but it seems like pretty much only because nobody realized he was dead and his body was 2 weeks decayed by the time anyone saw it. So foul play, barring something really violent, was probably, evidence would have been gone by then. So a lot of people, myself included, think that he might have actually been one of the first victims in all of this. We can't prove it at this point. Tylee was getting Social Security money as his daughter, as a beneficiary, and Lori was getting some money from that as well as the mother of Tylee. So she already knew how some of this worked. She would be getting money as the widow, but also as the parent of JJ. And of course, part of the charges in Idaho were fraud because she collected money as the mother of this minor, even though JJ had already passed away in September. She'd been collecting money in all the months since. The state continues. This statement by the party opponent about the life insurance proceeds is evidence of premeditation. The defendant later contacted the sister of Charles Vallow. Again, Kay. It's hilarious that in the state's brief, the case in brief, Kay's name comes up, and yet Lori is like, "Oh no, we need to strike her as a witness." She is so central to this case, Lori. Come on. The defendant later contacted the sister of Charles Vallow to confront her about the fact that Charles Vallow changed his life insurance beneficiary. The state will present testimony from an investigator with the Social Security Administration and iCloud documents to show that the defendant was aware of how much money from Social Security she would receive for her son, JJ, and herself as a result of the death of Charles Vallow before she went to speak to anyone at Social Security. This testimony and evidence further support that the defendant premeditated the murder of her husband. If you've been watching the other trials, it was not even a close call as to whether she was going to be found guilty. So I can't imagine that anything would change with this case, that it will be pretty easy to find her guilty in this one as well. This document ends saying the state will present testimony from witnesses who were friends with the defendant and iCloud documents to show that the defendant used her religious belief system as a way to premeditate the murder of her husband, Charles Vallow. These witnesses and documents were disclosed to the defendant on December 12th, 2023, January 9th, 2024, and February 26th, 2024. And then this document was filed with the court on March 23rd of 2025.
6.
And we have what I find to be ridiculous and offensive. Lori just decides to accuse the prosecution, the state, of prosecutorial misconduct.
Oh my gosh!
It's really tacky what she attempts to do here. She is saying that both of her cases, she wants them both to be dismissed because of prosecutorial misconduct of Trina J. K. So this is what she alleges in her filing. That on or about September 6, 2024, Trina K. directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defendant's right to investigation. 2. On or about January 30th, 2025, Trina K. obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. On or about March 11th, 2025, Trina K. gave legal advice to defense witness Nate Eaton in a, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense. Ms. K. has personally thrown her ethics and duties out the window in order to win this, quote, high-profile case in front of a worldwide audience. It is high-profile, not high-profile.
When people do this, I don't really know what that means.
And it would need a hyphen because it's a compound adjective, but I wouldn't expect Lori to know that. Yes, I am petty. I don't care if other people don't know how to use compound adjectives and other punctuation, but if you're on trial for these kinds of crimes, in my opinion, you are fair game for mockery. I will get petty. So then she continues, because this court has ignored the state's conduct, Trina K. became more blatant in her disregard for her ethical obligation. This is where her snark, to me, just crosses the line. She says, this is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a high-profile case.
Not using it right, Joe.
Years ago here in Maricopa County. It seems her behavior is not original. So, Juan Martinez, if you're not familiar, he was the prosecutor that was on the Jodi Arias case, which again was in Maricopa County as well. That's a case actually I'm thinking about covering. Let me know if you're interested, because that one definitely has an LDS connection as well. Very different, but it's Jodi Arias, really big nutshell. Completely slaughtered her boyfriend, but she joined the church and for the same reason, in my opinion, that Ted Bundy did, was because it would be a way for her to find easy marks. But yeah, she's in prison for life. And Juan Martinez did represent the state in that case, helped get her convicted. He has since been disbarred. We can go into all the details as to why, but it wasn't for prosecutorial misconduct. It was for sexual harassment, is my understanding. Comparing Trina K, and I don't know if they're even still dating or what the situation was there, but the idea that Lori is trying to it's just, she's mudslinging, and it's bad form. So she says, this court is obligated to discipline officers of the court for misconduct. This misconduct is egregious and needs to be addressed by the court. The actions that the defendant is seeking this court take as a result of Ms. Trina K's misconduct are as follows. 1. Removal from above cases for prosecutorial misconduct. And she keeps trying to insist that her right to a speedy trial has been violated. So if this were to work, it won't, but if this were to work and the judge were to remove Trina K from the case, that would delay the trial again, which would only give her more ammunition for, oh, my right to a speedy trial has been infringed, which is what I think she's banking on, being able to get that kind of technicality and her case overturned, because we know evidence isn't going to do it. And then number 2, sanctions by the court of dismissal charges, and 3, disbarment by the state of Arizona.
Sure, Jan.
7.
This is the prosecution's response. They request that this court deny the defendant's motion, as there has been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting that the, quote, facts, that's how you use air quotes, Lori, as alleged by the defendant as to each issue are simply untrue. This is number 1. On September 6, 2024, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state. The state also requested documents listed in defendant's public records request, from Gilbert Police Department. When the state obtained the documents that defense had requested from the Gilbert Police Department, the state disclosed them on October 1st, 2024. On September 18th, 2024, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police Department. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. So it's not on the prosecution, it's on Lori for filing that request wrong. And this is again why pro se is not always the greatest idea. You don't know. The state was advised. The Chandler Police Records Specialist section spoke with Laura Moyes, who sent a request for the quote log records for all digital devices downloaded. The state was also advised that the Chandler Police Department did not know what was being requested as quote log records, unquote. Chandler Police Record Specialist section advised Laura Moyes that when computer crimes detectives are involved in a case, their supplemental reports contain download information on all devices that the Chandler Police Department extracts data from. All reports relating to the download of Charles Vallow's devices had previously been disclosed to the defense. Additionally, all extractions relating to the download of Charles Vallow's devices have previously been disclosed. The state is unaware of any other public records requests to either Chandler Police Department or Gilbert Police Department by the defendant or her defense team. Here are the last 2 pages of her filing for this particular motion, so you can pause to read if you'd like. But let's take a look at her arguments in front of the judge on March 31st about these 2 issues, the whole thing, 1, 2, and 3. The last 2 deal with supposedly communications intercepted by the state that were attorney-client privilege, and Nate Eaton was somehow, she accused him of being involved in that. Let's see what she says to the judge and his response, because it is gold.
8.
Our 8th and final document. So the fun with this one is that it's in her handwriting. The other one that we saw was not, so I'm not sure why she sometimes apparently has access. She seems to sometimes have access to a printer or computer and other times does not. But here she is trying to exclude the state witnesses. She says, the defendant, Lori Daybell, requests that the state be ordered to exclude the following witnesses: for Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Facts. The state witnesses listed above are not for factual testimony. They only have to offer speculation and hearsay. So it's hilarious that she's trying to get Kay stricken. The Kay is at the center of so much of this. Like, not going to happen. This is not hearsay. This is not speculation. Kay knows of which she speaks. It was her brother who died. She was the beneficiary. She knew Charles feared for his life and feared for his son. That is not hearsay. Lori, you're trying to get Nate Eaton called as a witness, and anything he knows is by legal definition hearsay. She's just trying to play games, and it's just ridiculous. She is studying case law, so good for her for knowing that you should do that when you're a lawyer. And that the alleged witnesses were not in communication, maybe not with each other, but with other relevant people in the case. Okay. And had no knowledge prior to the alleged crime. I beg to differ. Based on her previous trial and Chad's trial, they know stuff. Their presence was not in location or proximity of the victims or the defendant. Not necessary to prove the charges, especially when we're talking about the events that led up to and that show premeditation. We don't need to have these people present when Charles actually died. We don't need witnesses of that event to be witnesses in court. Laura, I think you would know that. After all of your experience in court, you should know that. But how testimony is unlikely to assist because, among other things, that has nothing to do with the defendant's actual case. Again, beg to differ, sweetheart. It also talks about Brady. There haven't been Brady violations here, guys. So Brady violation is when the prosecution withholds evidence that would be exculpatory for a defendant, and that's a big deal. You know, if you have like clear information like DNA that doesn't match the defendant, and this is clearly the perpetrator's DNA, something like that. Right to due process and right to a fair trial. She is so getting due process and right to a fair trial above and beyond the idea that she would try to cite Brady. Oh gosh. The state's witnesses that requires an apostrophe to make it possessive. Otherwise, you're saying states, meaning a whole bunch of them, plural, many states, and you would just mean Arizona. Just saying, Lori. The state's witnesses above are meant to deprive the defendant the right to due process and right to a fair trial. I mean, seriously, the level the people have been bending over backwards to make sure she gets a fair trial, holy moly. I mean, just her trial in Idaho, they went so above and beyond. I mean, Judge Boyce was fantastic, making sure this was so fair. Every I dotted, every T crossed, so that nothing could be overturned on appeal. I mean, he was made sure. In conclusion, the defendant requests the above listed witnesses are excluded from testifying at trial since it was discovered in their pre-trial interviews that these witnesses have been communicating with each other. That's the first that she mentions that, which is so crazy to me. That's one of your major arguments. You don't put that in the conclusion. You make that as one of your arguments. They were, communicating with each other regarding the defendant. And unless this is during the trial, unless this is like colluding to find ways to make her guilty, there's no reason, to my knowledge, that potential witnesses wouldn't talk to each other. Like, if you've been through something really rough, of course you talk to each other. Like, especially if it's like, wow, Lori's evil. Lori continuing. None of these communications between these witnesses have been turned over to the defense from the state. Because they're probably just private conversations? What evidence do you expect to be turned over? These aren't like recorded police interviews. This is what? Okay. But she goes on. Quote, all three above mentioned state witnesses should be excluded from testifying at trial. And that is page 4, even though it says that it has 3 pages. So Lori is inconsistent and can't count. And also has no idea how to use air quotes or apostrophes or hyphens. So that's fun. Sorry, I have to laugh. If I don't laugh, I'll cry. And I have cried before, and I'm looking forward to this trial being over and her name being out of the news. Some people have said things like, why do we need to even have these 2 trials? She's already got 3 consecutive, not concurrent, life sentences in Idaho. And 2 big reasons I'm a fan of it. One is that Charles and Brandon deserve their own justice. They deserve to have guilty verdicts for what happened to them. But secondly, the justice system is wonky. And even when you think things are tied up in a tight little bow, sometimes things can be flipped on appeals on weird technicalities. So if, heaven forbid, we end up with something bizarre happening that would somehow vacate things or lower her sentences in Idaho, it will be good that we still have life sentences in Arizona so that she cannot walk free and hurt anybody else. In my opinion. The trial itself is just around the corner, guys. I will do my best to keep up on top of it, and it's going to be an exciting, wild ride, I imagine. Nate Eaton's already in Arizona. He's been posting stuff about his road trip down there. I think he's just assuming that the judge will make that ruling, and then he'll be there so he can go in when the ruling comes down. Since I recorded it, there have been some new updates. For one, Nate Eaton was struck as a witness, so he gets to be in court the entire time. Woohoo! Just as we guessed. And the judge pretty much had Lori losing every one of her motions, so she got pretty salty. And yeah, let's watch some of that.
Next have defendant's motion to dismiss for violation of confidential communication and the 6th Amendment dated March 18 of 2025 and the state's response. It appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really, that's about it. So how does this arise to some sort of nefarious interception of things, because it was put on a public chat system that the jail uses. You know it's not confidential. You're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication.
Who's saying that they're not confidential?
The
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged, confidential, client privileged communications. So
Phone calls.
from my no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
When his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney
Well,
privilege.
not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that.
All right, let me hear from the state.
The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. It's not just the defendant who is not complying with following the correct procedure. The defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call.
And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because of the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this
before.
is not confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? Miss Kate is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses. There was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state and that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's ordered denying the motion to dismiss for violation of confidential communication.
Stay tuned. The channel has been hovering around 5,600 subscribers. I would love to just bump it up over 6,000 for the trial. That would be so incredibly awesome. So if you haven't subscribed yet, please do. Like, share with your friends, all that good stuff. And until next time, if you'll excuse me, I gotta go get myself some chocolate.